Hello class, my name is Carlos Alvarado. This is week 6 for MPA 545. Quick overview, we're going to talk about early neutral evaluations, also known as ENE, dispute resolution board, mini trial, a summary jury trial, and I'm going to talk about a news story, my reference, and then the closing. The early neutral evaluation book summary, in the book, they're talking about that these ENEs are used for personal injuries or employment discriminations. And then the court usually appoints a third party that's neutral, and it's usually a lawyer that is very knowledgeable. Uh, the third party listens to both sides and he tries to give a legal opinion to give his thing, but it's not legal binding. And the good thing about the early evaluations, it's saves a lot of money and before going to the courts. In the journal article that I picked, they look into early and neutral evaluations and how it's used for intellectual property cases. And the authors found that intellectual property cases are very good with E&E uh, because one, it saves time, and also it helps not fill up the courts with, and because of these are a lot of cases that could be solved before going to an actual court. The book summary and the journal article are very similar because they both explain how E&Es are used in order to, one, get a resolution between both parties, and two, how to solve this before going into the court. The journal article expanded on early neutral evaluations because it showed how E&Es can be used for other things such as intellectual property cases, and how it's being successful in those type of cases. The dispute resolution board are used mostly for construction projects that have high risk and liability contracts, and each uh, side has a panel, and they are experts on their side. And the reason they use this is because it helps them prevent delays, because they're coming up with solutions as they agree on as time comes. The Dispute Resolution Board, a journal article that shows they looked into, they know that disputes are common in international projects, so they're trying to come up with a solution to prevent this, to have a model to be make sure that disputes are less in projects, and because that's, if it takes too long, that's costing the money, so they're trying to solve a problem by getting least amount of time to finish the project. So they're they found that they have a model trying to proceed so that there's a systematic and objective approach in management of the projects. The journal article and the book are similar because they both are looking into how to handle disputes in a high construction, high profile projects, and to help save time and money. The journal article expands on dispute resolution board by trying to create a system, statistical and method and management techniques that could be used in international projects, and so that way they could help resolve any disputes that come along the way. The mini trial book summary, it states that it's used for a non-binding voluntary structure hearing between disputants, and this usually takes place between 2 to 3 days. And this could be used for to resolve issues such as product liability, antitrust, contracts, patent infringements, and employment agreements. It's usually done by a well-respected attorney or a retired judge, and in some cases they do choose a three-panel party to, as the panel consists of one from each from each side and a neutral. And this is also pretty costly, so not that many people get to go this route just because of the cost base. But this does help prevent going into actual court, and that saves them money. The journal article summary by George Kumbi, he's talking about how the United States and Canada have commercial, uh, domestic commercial disputes, and how he's trying to use different ADRs to for a solution between them. He finds out that the mini trials work pretty well for this type of contract negotiations, and to help because it's trying to get a resolution before this thing goes to court. What was similar between the journal article and the book is that they're both talking about how it's pretty costly to go to court, but it kind of it's even though it costs a lot, it helps resolve the solution, and it's a great way for doing contract negotiations. The author goes to expand on mini trials. He calls them that they're structured negotiations, and he states that the United States and Canada using mini trials has helps solves disputes, and it's usually less cost effective than actually going to court, and it's time saving because um, they're both trying to get that the mini trial works best if they both are trying to get to an agreement. The book summary on summary jury trials is that this is a non-binding trial, and it is usually 1 day, and it's before you're going to full trial, and it's after follows the discovery phase of the case preparation. Because they're trying to save time, this eliminates any time-consuming tasks of jury trial in favor of a highly abbreviated format. And the the summary jury trial, it's very quick. Again, it's within 1 day, and if the parties do not agree on the outcome, then they can go to the full trial. The journal article summary by Charles Weber, he's talking about the summary jury trial on how they they're trying to see if it's an effective way to be used in the courts, and he states that some judges are evaluate themselves on how quickly they're able to process, but they're also looking for a way to help with the backlog. And he's stating how the summary jury trials are used in order to prevent cases going into a full jury trial, which will delay and make more backlog. And so that's what the journal is about. How the journal article and the book are similar is that they're both authors are stating that the summary jury trial is a great way to uh, help with backlogs and speed up the process of some of these cases. And because since summary jury trial is very quick, it's able to get to maybe a solution quicker than going through the full jury trial. And so that's how they are similar. The article by Charles Weber expands on summary jury trial because he's showing how judges are evaluate themselves based on how many cases they're able to process. And since the summary jury trial is very quick, more these judges are able to see how fast and good and effective they are by clearing some of the backlog. But also, he's stating that not every case should be going into the summary jury trial because there's some cases that are need some cross examinations, for example. So only certain cases should be able to be going to summary jury trial just to speed up the process and help with the backlog. The news article that I chose is between Metrolinx and Bombardier, and Metrolinx is the company that runs the trains. Bombardier is the one that builds the trains, and they are going between a contract negotiation between the builder not able to produce enough, how they negotiated in the contract, and that is what is causing this problem. This news article is related to the book because of Dispute Resolution Board. These two companies are trying to solve their negotiation through the Dispute Resolution Board, trying to fix the contract and make sure not to break it. And so that is how these two go together based on the book. The interesting thing about this article that I found is how dispute resolution board is actually used in real life situation. I never really understood this. Now I could see how The dispute resolution board was created just so it helped prevent delays, and because this company cannot keep up with the contract negotiate that they agreed on, now the Metrolinx is behind in providing new rails for the community of Toronto. And I find that the dispute resolution board is created to help prevent these situations. Feel free to pause for references to use on for your own purposes. Thank you again for your time and watching my video, and have a great week.